The deed was 43 pages long, and Marcus Chen read every word of it twice. That was not unusual for him. In 26 years with the Army Corps of Engineers, he had read contracts the way other men read maps, not for the general direction, but for the precise elevation, the exact coordinates, the specific language that would matter when everything else went wrong. He had managed infrastructure projects in Kuwait, in the Philippines, in the flooded lowlands of Louisiana after Katrina, and in every one of those places, he had learned the same lesson. The document you didn't read carefully enough was always the one that destroyed you. So he read the deed twice. Then he read the survey report. Then he drove out to the property alone, before the closing, before the celebration, and before his wife Patricia and their 3 adult children arrived with their excitement and their plans and their photographs of what the compound might look like someday. He drove out alone with a topographic map printed on 11 by 17 paper and a pair of boots he'd owned since Fort Bragg, and he walked the boundary lines of all 1,200 acres himself. It took 3 days. On the morning of the second day, standing at the eastern edge of his property, where the land dropped gently toward Clearwater Creek, he found the bridge. It was a solid structure, poured concrete abutments, steel decking, a single span of maybe 60 feet crossing the creek at its narrowest navigable point. Someone had maintained it with reasonable care. The concrete showed patching work, recent enough that the color hadn't fully weathered to match the original pour. The steel had been treated against rust within the last few years. A small yellow sign on the near railing read, "Weight limit 40 tons." And below that, in smaller letters, "Maintained by Clearwater Ridge HOA." Marcus stood at the edge of the bridge for a long time. He looked at his topographic map. He looked at the survey pins he'd been tracking all morning, the small orange flags his surveyor had placed along the boundary line. He looked at the road that crossed the bridge, a paved 2-lane that ran northeast through a corridor of his property for 2.3 miles before connecting to County Road 7. He looked at the sign again, then he took out his phone and photographed everything. The sign, the abutments, the survey pins on both banks, and the road as it disappeared into the tree line heading toward the cluster of homes he'd seen from the ridge, the Clearwater Ridge development, 340 houses arranged in careful crescents around a central clubhouse, the kind of community that had a newsletter and a landscaping committee and apparently a homeowners association with a maintenance budget and a sense of ownership over things it had never actually owned. He didn't say anything to anyone that day. He finished walking the boundary, made his notes, drove back to the motel in Hargrove where he was staying, and spent the evening with the historical property records he'd requested from the county clerk's office 3 weeks earlier. The original easement was dated June 14, 1984. It had been granted by a farmer named Eldon Pruitt, who owned the entire valley at the time and sold the eastern 800 acres to a development company called Ridgeline Properties LLC. The easement gave Ridgeline and its successors the right to use a defined corridor, 20 feet wide, following the existing farm road, for vehicular access to County Road 7. It was a standard access easement, recorded properly, legally binding, and it ran with the land. Whoever owned the 1,200 acres would be bound by it. Marcus had known about the easement before he made his offer. It was disclosed in the title search. It was not a surprise. What the title search had not flagged, because no one had thought to look, was the bridge. The bridge was built in 1987, 3 years after the easement was recorded. Marcus found the county construction permit in the historical records. Permit number 87-441, issued to Ridgeline Properties LLC for the construction of a single-span vehicular bridge at the coordinates he'd photographed that morning. He cross-referenced those coordinates against the easement corridor. The bridge was not in the easement corridor. The easement ran 20 feet wide along the center lines of the Old Farm Road. The bridge, as built, sat 14 feet east of that center line. 14 feet outside the legal boundary of the easement, sitting, in its entirety, on what was now Marcus Chen's property. He set down the permit and looked at the ceiling of his motel room for a while. He was not a man who celebrated prematurely. He was not a man who assumed that a discovered advantage was a guaranteed victory. He had seen too many projects collapse because someone found a favorable clause in a contract and stopped reading. Once so he kept reading. He went through every subsequent document, the transfer of the development from Ridgeline Properties to the Clearwater Ridge HOA in 1991, the maintenance records, the county inspection reports, the insurance filings. He looked for any document that acknowledged the bridge's location, that granted the HOA any right to the land beneath it, that established any legal basis for their maintenance claim. There was nothing. Not a maintenance agreement, not a license, not an acknowledgement of encroachment, not a single piece of paper in 37 years of bridge maintenance that suggested anyone had ever checked whether the structure they were maintaining sat on land they had any right to touch. They had simply assumed. The bridge was there. The bridge served their community. Therefore, the bridge was theirs. And Marcus understood that assumption. He'd seen it operate in institutions his entire career. The quiet, confident presumption of possession that comes from long, uncontested use. The army did it. Contractors did it. Municipal governments did it. Organizations that had been doing something for decades developed a kind of institutional memory that replaced actual legal authority. We have always done this. Therefore, we have the right to do this. It was not malice, usually. It was something more dangerous than malice. It was certainty without verification. He closed the folder of historical records and made himself a cup of bad motel coffee and thought about what to do with what he knew. The closing was in 4 days. After that, the 1,200 acres would be his, completely, legally, unambiguously his, but as clean a title as the county recorder's office had ever processed. His surveyor, a meticulous woman named Diane Okafor, who had been doing this work for 30 years, had found no encumbrances beyond the recorded easement. The property was unencumbered. The bridge was on his land. The HOA had no legal claim to it. He could have called the HOA before the closing. He could have introduced himself, explained what he'd found, proposed a conversation about a proper maintenance agreement or corrected easement. That would have been the neighborly thing to do. He was not, by nature, an adversarial man. He had spent his career building things, not tearing them down. But he'd also spent his career watching what happened when you showed your hand too early. When you disclosed a problem before you understood the full shape of the institution you were dealing with. You gave them time to prepare. You gave them time to find their own lawyers, to construct their own narrative, to reframe your discovery as your aggression. So he said nothing. He closed on the property on a Tuesday in late April, shook hands with the title company representative, signed his name 43 times, and became the legal owner of 1,200 acres of Clearwater Valley, including the bridge that 340 households drove across every single day without knowing who owned the ground beneath it. He gave himself 2 weeks to settle in before he contacted the HOA at all. 2 weeks to set up the temporary trailer that would serve as his base of operations while he planned the compound. In 2 weeks to meet his nearest actual neighbors, a retired schoolteacher named Harold Birch, who farmed the parcel to the north, and a quiet family named Ostrowski, who kept horses on the western boundary. 2 weeks to simply be present on the land, to learn its rhythms, to understand what he had bought. On the 15th day, he received a letter. It was from the Clearwater Ridge Homeowners Association, signed by the board president, a woman named Victoria Ashford. It was 2 pages long, professionally formatted, and written in the careful language of institutional authority, the kind of language that implies legal weight without quite committing to specific legal claims. It welcomed him, briefly, to the area. Then it informed him that the HOA had become aware of his recent acquisition and wished to discuss the community impact of his planned development. It referenced, without specifics, the HOA's interest in maintaining the character and standards of the Clearwater Valley area. It requested a meeting at his earliest convenience. It did not ask about his intentions. It did not introduce itself as a neighbor. It positioned itself from the first sentence as an authority. Marcus read it once. He set it on the folding table next to his survey maps and his folder of historical property records. He looked at the photograph he'd printed and pinned to the wall, the bridge over Clearwater Creek, the yellow HOA sign on the railing, the survey pins on both banks marking the boundary of his land. He wrote the date on the letter in pencil. He filed it in a new folder he labeled Clearwater Ridge HOA and began waiting to see what kind of institution he was actually dealing with. He already knew what the bridge was worth. He was about to find out what they were worth. The letter arrived on a Tuesday, which Marcus would later think was fitting. Tuesdays had no drama to them, no weight. They were the kind of day bureaucracies preferred, unremarkable enough that what they delivered could be mistaken, at first, for something routine. He read it standing at his kitchen table, still in his work clothes. Dust from the survey stakes on his boots. The letterhead was embossed. Clearwater Ridge Homeowners Association, Community Standards Division, a title that had not existed 6 weeks ago and had been created, he would later confirm, specifically for this purpose. The language was formal in the way that people who are not lawyers write formal language. Slightly too many clauses, slightly too much confidence. The grammar of people who have decided that sounding official is the same as being official. The ordinance was titled Resolution 2024-07, Community Aesthetic and Adjacent Property Standards. It ran 4 pages. Marcus read it twice, slowly, the way he had learned to read contracts in the Corps, not for what they said, but for what they assumed. What it assumed was extraordinary. The HOA had voted, at a special session 2 weeks prior, to extend their jurisdiction to cover all properties within visual range of Clearwater Ridge that could, in the board's determination, affect community aesthetics, property values, or the residential character of the development. The resolution cited the HOA's founding documents, a 1983 Declaration of Covenants, conditions, and restrictions, as the authority for this expansion. It cited case law from 3 states, none of them this one. It cited a county planning memo from 2019 that Marcus pulled up on his laptop within 20 minutes and confirmed had nothing to do with private HOA authority over non-member properties. At the bottom, above the signature of Victoria Ashford, board president, was a notice of violation. Marcus Chen, owner of the parcel designated County Tax ID 7741-A, was hereby found in non-compliance with Community Aesthetic Standards, Section 4, Subsection C, which prohibited the visible storage of construction materials, survey equipment, and temporary structures on adjacent properties without prior HOA approval. He had survey stakes in the ground, a portable generator under a tarp, 2 pallets of drainage pipe he'd had delivered the week before. He set the letter down. He picked it up again. He read the violation notice one more time, and then he did something that surprised even him. He laughed, not bitterly, not the laugh of a man who finds nothing funny. It was the genuine involuntary laugh of someone who has just watched a person walk confidently into a wall. Because Marcus Chen had spent 26 years in the Army Corps of Engineers. He had managed infrastructure projects in Kuwait, in Germany, in the Philippines, in places where the legal frameworks governing land use were written in languages he didn't speak, and he had learned to read those frameworks anyway, because in his profession, the difference between a legal structure and an assumed one was the difference between a bridge that stood and a bridge that didn't. He had an instinct for load-bearing assumptions. He could feel when something was holding weight it was never designed to hold. The HOA's ordinance was holding an enormous amount of weight on a foundation that did not exist. He called his attorney, Daniel Reyes, that evening. Reyes was a property rights lawyer out of the county seat, a compact, methodical man who had spent 15 years untangling rural land disputes and who had, in their first meeting, told Marcus that the most dangerous people in property law were not criminals, but optimists, people who were absolutely certain they were right without having checked. Marcus had liked him immediately. He read Reyes the resolution over the phone. There was a long pause. "They passed this at a special session," Reyes said. It was not quite a question. 2 weeks ago. I wasn't notified. I'm not a member." "You're not a member," Reyes repeated, and Marcus could hear him writing. "They've cited their own CC&Rs as authority to regulate non-member property." "Correct. Their CC&Rs are a private contract between the HOA and its member homeowners. They have no legal force over anyone who didn't sign them." That's my read. "Marcus." Reyes paused again. "This is not a grey area. This is not a situation where reasonable people disagree. A homeowners association has no statutory authority to regulate land outside its defined boundaries, none. They can pass all the resolutions they want. They can call it whatever they want. The moment they try to enforce it against you, they're acting without legal authority. That's not a technicality. That's the whole thing." Marcus knew this. He had known it before he called. But there was a difference between knowing something and having a lawyer confirm it in the measured, careful tone of someone who was already thinking 3 moves ahead. It made the thing real in a different way. "So we send a response," Marcus said. "We send a response," Reyes agreed. "Politely, clearly. We inform them that their ordinance has no legal application to your property, that you are not subject to their CC&Rs, and that any attempt to enforce this resolution against you will be met with appropriate legal action. We keep it professional. We don't threaten, we just state the facts. And if they ignore it?" Reyes was quiet for a moment. "Then we find out what kind of people we're dealing with." The response letter went out the following Monday. Marcus kept a copy. He was keeping copies of everything now, not out of anxiety, but out of habit. The same habit that had made him the officer other officers called when a project went sideways, when the paperwork didn't match the ground truth, when someone needed to reconstruct exactly what had happened and when. He had a filing system. He had a dedicated email folder. He had begun photographing his property every morning, time-stamped, the survey stakes and the generator and the drainage pipe exactly where they were, unchanged, in compliance with every actual law that applied to him. He was building a record. He didn't know yet exactly what he would need it for. But he had learned. In 26 years of managing large projects in complicated environments, that the people who won the long arguments were almost never the loudest. They were the ones who had written things down. The HOA's response came 8 days later. It was not a retraction. It was not an acknowledgement that their ordinance might have overstepped. It was a second notice of violation, this one citing an additional provision, Section 7, subsection A, which prohibited adjacent property owners from undertaking any land modification that could alter drainage patterns affecting Clearwater Ridge. Marcus had, according to the notice, installed drainage pipe in a manner that required immediate review and approval. He had installed drainage pipe on his own land, in accordance with a county-approved drainage plan, aimed to manage runoff from a slope that had nothing to do with Clearwater Ridge's water table. He had the county approval on file. He had the engineer's report. He had the survey data showing the drainage flow direction, which ran away from the HOA's property, not toward it. None of that was in the violation notice. The violation notice contained only the assertion. He sat with this for a while. Not because he was uncertain, but because he was trying to understand the logic. Not Victoria Ashford's logic, not the board's logic, but the institutional logic, the way this kind of power structure thought about itself. He had seen it before, in the military, in contracting agencies, in county planning departments. It was the logic of an organization that had operated without challenge for long enough that it had confused its own preferences with authority. The HOA had governed Clearwater Ridge for 40 years. They had written ordinances and enforced them and watched people comply. And somewhere in those 40 years, they had stopped distinguishing between the power they had over their members and the power they imagined they had over the world adjacent to their members. They were not malicious exactly. They were something more dangerous. They were certain, and their certainty had made them careless. Careless about what they actually owned. Careless about what they had actually checked. Careless about the man they were sending violation notices to and what he might know that they didn't. Marcus walked out to the bridge that afternoon. And he did this sometimes, not to look at the bridge itself, but to look at the survey markers he had placed on either side of it. Small orange flags in the ground, precise to within 2 inches, marking the boundary of his property. The bridge sat entirely within those flags, the eastern abutment, the western abutment, the span itself, all of it on his land, as it had been since 1987, when the original developer had built it without securing a proper structural easement, relying instead on a handshake understanding with a farmer who was dead and whose heirs had sold the land to Marcus Chen without anyone ever stopping to ask whether the bridge had a legal home. It did not. It had a physical location. Those were different things. He stood there in the late afternoon light, the creek running below, the sound of it steady and indifferent, and he thought about patience, about the difference between the moment you discover leverage and the moment you use it. He had learned this distinction not in a classroom, but in the field. Managing projects where the wrong move at the wrong time could cost months of work, where the temptation to act on what you knew had to be balanced against the question of when acting would actually matter. He wasn't ready yet. The HOA was still building their case, still accumulating their certainty, still writing ordinances that had no authority, and sending notices that had no legal force. Let them build. Let them feel the weight of their own confidence. He photographed the survey flags. He photographed the bridge. He noted the date and time in his log. And then he walked back to the house and called his surveyor to schedule a formal structural assessment of the bridge's footprint, a document that would establish, with professional precision, exactly where every inch of that structure sat in relation to the property line. He was not escalating. He was preparing. There is a difference, and Marcus Chen understood it completely. The letter from his attorney arrived on a Tuesday, which Marcus would later remember as the day the war changed character. Not the day it started. That was months behind him now, buried under a sediment of certified mail and county filing numbers, and the particular exhaustion that comes not from physical labor, but from being perpetually, institutionally wrong in someone else's eyes. Tuesday was the day it stopped feeling like a dispute and started feeling like a siege. Daniel Reyes, his attorney, had written the letter with the careful neutrality of a man delivering a terminal diagnosis. The HOA's lawsuit had survived its first motion to dismiss. The judge, a county appointee who had, Marcus had quietly noted, attended the same civic fundraiser as Victoria Ashford 2 years running, had found sufficient grounds in the nuisance by anticipation claim to allow discovery to proceed. They would now spend the next several months exchanging documents, depositions, and legal theories about something Marcus had not done, had no intention of doing, and had every right to do if he chose. His legal bill was at $94,000. He sat with that number at the kitchen table of the rental house he was living in, the family compound still unbuilt, still a set of architectural drawings rolled in a cardboard tube in the corner of the room. And he did the arithmetic that had become a nightly ritual. Savings, diminishing. Timeline, expanding. Contractor, gone. The firm he'd hired, Delgado Construction, had withdrawn 3 weeks earlier with a polite but firm letter citing unresolved litigation risk. They'd refunded his deposit, which was the only decent thing anyone connected to this situation had done for him in months. Patricia came in from the other room and saw the letter on the table. She didn't ask. She'd stopped asking what the letters said, because the letters always said the same thing in different configurations. More time, more money, less certainty. Daniel thinks we should consider the settlement framework, Marcus said. She sat down across from him. She was 51 years old and had spent 26 years being the person who held things together, while Marcus was deployed, reassigned, or consumed by some infrastructure crisis on the other side of the world. She was not a fragile woman, but there was something in her eyes now that Marcus recognized from the faces of soldiers who had been in the field too long. Not fear exactly, but the particular weariness of someone who has been asked to sustain a position without knowing if the position can be held. "What does the settlement look like?" she asked. "Agricultural use restriction on the full 1,200 acres. All future development plans submitted to HOA review. A recorded covenant running with the land." He paused. "Permanently?" She was quiet for a moment. "And if we sell someday?" "The covenant transfers. Whoever buys it is bound by it." She looked at the cardboard tube in the corner. The drawings inside it. The main house, the guest quarters, the barn, the small orchard they'd planned along the eastern ridge, had been designed by an architect friend who charged them a fraction of his normal rate as a favor to a veteran. Marcus had spent 6 months describing what he wanted. The architect had spent 3 months making it real on paper. The compound wasn't extravagant. It was in the specific way of things built by people who have spent decades without a permanent home, an act of intention, a declaration that this was where they would be. "No," Patricia said. Marcus looked at her. "No settlement," she said. Not that one." He hadn't expected that. He'd been bracing for the conversation where she asked him to be reasonable, to weigh the cost against the principle, to accept that sometimes institutions win not because they're right, but because they're expensive to fight. He'd been rehearsing his response to that conversation for weeks. Instead, she reached across the table and tapped the cardboard tube. "You told me this land was ours. Clean title, no encumbrances. You told me you checked everything." "I did." "Then it's ours, and I'm not signing it over to Victoria Ashford, because she's decided she gets to decide what we do with it." He felt something shift in his chest. Not relief exactly. Something older than relief. The HOA had by this point constructed a remarkably complete apparatus of pressure. The community petition had gathered signatures from 212 of the Ridge's 340 households, a number Victoria had made sure was reported in the Clearwater Valley Gazette alongside a quote about protecting the character of our community. The article had described Marcus as a developer despite the fact that he had filed for permits to build a single-family residence. The reporter had not called him for comment. The HOA's attorney had filed 2 additional complaints with the county, one alleging improper grading activity near the easement corridor, activity that consisted of Marcus walking his property line with a GPS unit, and one claiming his survey stakes constituted unauthorized encroachment. Both complaints were thin enough to be laughable, but both required responses, and responses cost money. And that was the point. What the HOA did not know, what Victoria Ashford, with her real estate instincts and her institutional confidence, had never thought to investigate, was that Marcus had spent those same months building something of his own. He had a filing system, not digital, though he had digital backups, physical, hanging folders in a fireproof cabinet he'd bought at an army surplus sale, organized by date and category. Every letter the HOA had sent him, every county communication, every newspaper article, photographs of the easement road, time-stamped, showing its condition and its boundaries, photographs of the bridge, the Clearwater Creek Bridge, the one the HOA maintained, the one that carried their road, the one that sat on his land, taken from 6 angles, with survey markers visible in the frame. He had the original 1984 easement document, pulled from county records. He had the 1987 building permit for the bridge, which listed the property owner of record as James Whitfield, the farmer who had sold the eastern portion to develop Clearwater Ridge. He had the chain of title showing that the bridge parcel had passed through 2 subsequent owners before Marcus purchased it as part of his 1,200-acre acquisition. He had a structural engineer's assessment of the bridge, commissioned quietly, which confirmed that the bridge was a permanent improvement affixed to the land, not to the easement corridor, but to the parcel itself. He had a legal memorandum from a property rights specialist in the state capital, not Daniel Reyes, who was a good general litigator, but not the right instrument for what Marcus was beginning to understand this situation required. Analyzing the easement's precise language. The easement granted a right of passage. It granted nothing else. It did not grant the right to maintain structures on the underlying property. It did not grant the HOA any authority over the landowner. It did not, in any clause or subclause or implied provision, give Victoria Ashford or her board or their attorney or their 212 petition signatories any legal standing over Marcus Chen's 1,200 acres. The bridge was his. The road ran through his property by permission. Permission that was recorded and binding, and that Marcus had no intention of revoking. But permission was not ownership. The HOA had spent 37 years maintaining a structure on land they did not own, had never owned, and had never thought to verify they owned. Marcus had known this since the second week of ownership. He had found it in the records the way a military engineer finds a structural flaw, methodically, without drama, following the documentation wherever it led. He had noted it. He had filed it. He had said nothing. He was not ready yet. The position wasn't right. In the core, you didn't commit your decisive asset before the enemy had fully extended themselves, before their confidence had outrun their intelligence, before the moment when the weight of their own certainty would become the instrument of their undoing. The HOA was still extending, still confident, was still certain that the cost of refusal would eventually exceed Marcus's capacity to refuse. They were doing the wrong arithmetic. He closed the legal bill, set it aside, and pulled the property records folder from the cabinet. He spread the documents on the table, the easement, the bridge permit, the chain of title, the engineer's assessment, and looked at them the way he had looked at infrastructure maps in the field, not with anger, with the specific cold clarity of a man who knows where the load-bearing elements are. Patricia watched him from across the table. "You have something," she said. It wasn't a question. "I have everything," he said. "I've had it for months." "Then why are we still—" "Because the moment I use it, it's used." He looked up at her. "Right now they think they're winning, and I need them to keep thinking that a little longer." Outside, the October wind moved through the valley. Somewhere beyond the rental house, beyond the county road, beyond the easement corridor and the bridge and the 212 signatures, his 1,200 acres sat in the early dark, patient and indifferent and entirely, legally, unambiguously his. The county recorder's office smelled like old carpet and toner fluid, and Marcus had been sitting at the same microfiche terminal for 4 hours when he found it. Not the easement itself. He'd had that since week 2, folded into a manila envelope with the rest of the title documents, clean and unambiguous as a military order. What he found on that Tuesday afternoon in November, under fluorescent lights that hummed at a frequency designed to make you feel slightly unwell, was something smaller. a survey addendum from 1987. 3 pages, handwritten annotations in the margins, stamped and recorded by a county surveyor named Dale Hutchins, who had apparently retired in 1994 and died in 2011. The addendum described, in the dry and precise language of land measurement, the exact placement of a concrete bridge structure spanning Clearwater Creek. The coordinates placed it 14 feet west of the easement corridor boundary. 14 feet, the width of a modest living room, the length of a pickup truck, enough to matter completely. Marcus didn't react. He'd trained himself out of visible reactions during his second deployment, when the ability to receive bad news without flinching was the difference between a unit that held and a unit that fractured. He photographed the addendum with his phone. 12 photographs, overlapping, every corner captured, and then he sat for a moment with his hands flat on the table and thought about what he was holding. The HOA had filed their nuisance suit 6 weeks earlier. Victoria Ashford's attorney, a man named Garrett Holloway, who wore suits that cost more than Marcus's first car, had submitted 47 pages of documentation asserting that Clearwater Ridge had maintained the bridge and the road corridor for 4 decades, establishing a pattern of community stewardship that the court should recognize as a de facto property interest. The language was confident. It was meant to be. Holloway had built his career on making institutional overreach sound like civic virtue. What Holloway's 47 pages did not contain was a survey. Not one. No one had checked where the bridge actually sat in relation to the easement boundary. They had assumed. 4 decades of assumption, compounded annually, until the assumption had calcified into something that felt indistinguishable from fact. Marcus requested copies of the addendum and paid the $12 reproduction fee at the front desk. The clerk, a woman with reading glasses on a beaded chain, asked if he'd found what he was looking for. He told her he thought so. She said that was good, because most people who came in looking like he looked, she gestured vaguely at his face, usually left disappointed. He thanked her and drove home. The paper trail had started 3 months earlier, the week after the HOA sent their first formal letter. Marcus had approached it the way he'd approached infrastructure assessments in the Corps, not looking for what he expected to find, but cataloging everything that existed, and then asking what it meant. He'd pulled the original 1984 easement grant, the 1987 construction permits for the bridge, the county maintenance records from 1987 through 2003, and then the gap, a 7-year gap in county records that corresponded precisely to the period when the HOA had assumed full maintenance responsibility and stopped filing the paperwork that would have kept the bridge in the public record. That gap was its own kind of document. He'd built a binder, then 2 binders, then a filing system that occupied one wall of the spare bedroom Patricia had stopped calling the guest room and started calling the war room, which she said with a tone that was equal parts affection and worry. The binders were color-coded. Red for HOA communications and legal filings, blue for county records, green for his own property documentation. The title, the survey, the deed, the title insurance policy, the Phase 1 environmental assessment, every piece of paper that established, in layered and redundant detail, that 1,200 acres of Clearwater Valley belonged to Marcus James Chen, free and clear, without encumbrance. The green binder was the thickest. His lawyer, a woman named Diane Okafor, who had spent 15 years in real estate litigation before opening her own practice in the county seat, had reviewed the easement documentation in September and told him it was solid, but not decisive. The HOA's claim wasn't that they owned the easement. They knew they didn't. But their claim was that his property, by virtue of its adjacency and visibility, fell within a sphere of community interest that the court should recognize. It was a novel theory, she said. Novel theories sometimes won. Marcus had asked her what would make it not novel. She'd said something that reframes the entire relationship between the parties. something that changes who has leverage over whom. He hadn't told her about the bridge coordinates yet. He'd been waiting to understand the full shape of what he had before he showed anyone the pieces. Now, driving back from the county recorder's office with the addendum copies on the passenger seat, he began to understand the shape. The HOA had filed suit claiming a community interest in his property. That they had done this while maintaining a structure on his property. A structure they did not own, had never owned, and had no legal agreement to maintain. They had done this while simultaneously arguing in court that their 40 years of stewardship demonstrated a kind of moral ownership that should constrain what he could do with his land. The bridge was the load-bearing element of that argument, and the bridge was his, not the road. The road ran through a legitimate easement, and Marcus had no intention of challenging it. He wasn't trying to strand 340 families. He wasn't Victoria Ashford. He didn't punish people for the possibility of future offences. But the bridge was different. The bridge was a structure on his property, maintained without permission, without a maintenance agreement, without so much as a letter acknowledging that it sat on land belonging to someone else. And the HOA had spent the last 4 months filing legal documents, organizing community petitions, pressuring county officials, and spending their members' dues on Garrett Holloway's hourly rate, all while standing on a foundation they'd never bothered to verify. Marcus thought about the survey addendum, 14 feet. Dale Hutchins, county surveyor, retired 1994, deceased 2011, had recorded the precise location of that bridge in a document that had sat in the county recorder's office for 37 years, available to anyone who looked. No one had looked. He pulled into his driveway and sat in the truck for a moment. The late afternoon light was doing something particular to the ridgeline to the east, turning the tree line amber and copper, the way it did in November when the angle was right. He'd bought this land partly for that view. He'd told Patricia it was practical, the acreage, the water rights, the soil quality, but the truth was he'd stood on this ground during the site visit and watched the light move across the ridge and felt something he hadn't felt in 26 years, of concrete and logistics and institutional machinery. He'd felt like the land was his before he'd signed a single document. It was his. Every surveyed inch of it. He picked up the addendum copies from the passenger seat and went inside. Diane Okafor answered on the second ring. He told her he'd found something at the county recorder's office, and he wanted to meet tomorrow morning, first thing. She asked if it was significant. He told her it reframed the relationship between the parties, and that there was a pause on her end. He could hear her thinking. She said, "How much does it reframe it?" He looked at the addendum in his hand. 3 pages, handwritten annotations. A stamp from 1987. 37 years of an assumption that had never been tested because no one had thought to test it. He said, "Enough." He didn't say more than that. He'd learned in the Corps that the moment you explain your leverage before you've secured your position is the moment you lose it. The HOA had spent 4 months explaining their leverage, their ordinances, their petitions, their legal theories, their community solidarity. They'd been loud and certain and institutional. Marcus had been quiet. The paper trail didn't care about noise. It cared about coordinates. Ways it cared about a survey addendum recorded in 1987 by a man named Dale Hutchins who had done his job correctly and filed his paperwork and gone home, never imagining that 37 years later, 14 feet would mean everything. Marcus set the addendum on the kitchen table beside the green binder. He made coffee. He waited for Patricia to come home. He did not tell her yet what he'd found, because he wanted one more evening of the thing they'd had before all of this. The quiet, the ridgeline, the sense that the land was simply theirs and the world had not yet arrived to dispute it. Tomorrow, the world would find out what it had missed. The survey report arrived on a Tuesday morning in November, when the frost had just begun to stiffen the grass along Clearwater Creek, and the water ran low and dark between its banks. Marcus stood at his kitchen table in the farmhouse he'd been renting since his contractor walked away, and he read the document 3 times. Not because he didn't understand it the first time. He understood it perfectly the first time. He read it 3 times because he wanted to be certain that what he was feeling, that slow, quiet expansion in his chest, the thing that wasn't quite satisfaction and wasn't quite relief but lived somewhere between the two, was warranted, that he wasn't misreading, that the numbers and coordinates and legal descriptions were saying exactly what he thought they were saying. They were. He set the report down on the table beside his coffee cup and looked out the window toward the tree line where his property began, where the creek bent south and the old bridge carried the road across it. And he thought about a man he'd served under in Germany, a colonel named Reyes, who had a saying he repeated every time a situation looked irretrievable. "The other side always leaves a door open," Reyes used to say. "They just assume you won't find it." Marcus had found the door. He'd known it was there since the 2nd week of ownership. He'd been waiting for the right moment to walk through it. The survey had been commissioned quietly, through a firm in the state capital rather than the county, because Marcus had learned by month 3 that the HOA had relationships with every professional service within 40 miles of Clearwater Ridge. Victoria Ashford's fingerprints were on the county planning office, on the local engineering firms, and on the newspaper that had run 3 separate pieces framing Marcus as a speculative developer looking to industrialize a quiet community. He'd learned to operate outside her radius of influence. He'd learned, in other words, to think like an engineer again, to map the terrain before he moved across it. The survey confirmed what the historical property records had suggested, and what Marcus had suspected since the first week he'd walked his land with a copy of the 1984 easement agreement in his jacket pocket. The easement itself was legitimate. It was recorded, legal, and binding, a 2.3-mile right-of-way granted by the original landowner, a farmer named Eldon Marsh, to allow road access through the property that would eventually become Clearwater Ridge. The HOA had maintained that road for 40 years. They had every right to do so. The easement said so clearly. What the easement did not say, what it had never said, what no document in the county recorder's office had ever said, was that the bridge belonged to them. The bridge had been built in 1987, 3 years after the easement was recorded. It had been built to span a section of Clearwater Creek that sat 14 feet east of the easement corridor's legal boundary. 14 feet. Not a dramatic distance. Not a distance that anyone driving across the bridge would ever notice or care about. But in property law, 14 feet is the difference between a structure built on your land and a structure built on someone else's land. And the someone else, in this case, was whoever owned the 1,200 acres that Eldon Marsh had retained when he sold the eastern portion to the Ridge's original developer, or that someone else was now Marcus Chen. He had a licensed surveyor's certified report, stamped and notarized, establishing the bridge's precise coordinates. He had the original 1984 easement agreement, which he'd obtained from the county recorder's office on his 3rd visit, after the clerk had twice told him the records were in storage and unavailable. He had the 1987 construction permit for the bridge, which listed the contractor, the dimensions, and the GPS coordinates of the structure. Coordinates that, when plotted against the easement boundary, placed the bridge unambiguously on the retained parcel, on Marcus's land. He also had something else, something he'd assembled over the previous 4 months with the same methodical patience he'd once applied to infrastructure assessments in places where the cost of error was measured in lives rather than dollars. He had a file. It was not a thin file. It was 4 inches thick and organized into tabbed sections. The HOA's original citation letter, the Community Standards Ordinance they'd passed in month 1, the formal demand that he restrict his land to agricultural use, The lawsuit filing, the newspaper articles, the county's permit denial letters, the emails his attorney had exchanged with the HOA's counsel, and this was the section Marcus considered most valuable, a log of every conversation, every interaction, and every phone call and site visit and neighbor encounter that had occurred since the day he'd received the first citation. Dates, times, names, exact language where he could remember it, approximate language where he couldn't. He'd started the log on day 8 of ownership, before the harassment had fully materialized, because he'd felt something in that first citation letter that his military instincts recognized immediately. The particular confidence of an institution that had never been challenged. Institutions like that, in his experience, were sloppy. They didn't document carefully because they'd never needed to. They assumed their authority was self-evident, and so they exercised it carelessly, leaving a trail of overreach that only became visible when someone bothered to look. Marcus had looked, and Marcus had done nothing but look for 4 months. He called his attorney that afternoon. Daniel Okafor had been practicing property law in the state for 19 years, and he was the third attorney Marcus had consulted, the first two having advised settlement within the initial meeting. Okafor had not advised settlement. Okafor had listened to the full account, examined the easement documents, and said, with a careful neutrality that Marcus had come to respect, "Tell me more about the bridge." Now Marcus told him about the survey. There was a silence on the line that lasted long enough that Marcus checked to make sure the call hadn't dropped. "Say that again," Okafor said. "The bridge footings. Both sets, east abutment and west abutment, both on my property. The easement corridor ends 14 feet west of the west abutment." Another silence. Then, "They've been maintaining a structure on your land for 37 years. Without a maintenance agreement," Marcus said, "without an easement amendment, without any legal instrument granting them the right to access, modify, repair, or use that structure. And the bridge is the only crossing. The creek runs for 11 miles in each direction before you hit another road crossing. The county bridge is 9 miles north. There's no alternate route to the highway that doesn't add 45 minutes to the drive." Okafor was quiet again, and Marcus could hear the particular quality of that quiet, the sound of a lawyer recalculating. "Marcus," he said finally, do you understand what this means for their lawsuit?" "I have some thoughts. Their entire legal position assumes they have the standing to regulate adjacent properties because of community impact. But if the bridge is yours, if the only physical connection between Clearwater Ridge and the county highway runs across your land without a valid legal instrument, then they're not a community with a legitimate interest in adjacent development. They're 340 households whose access to the public road network depends entirely on your goodwill." "That's my read," Marcus said. "They filed suit against you for what you might do to their community," Okafor said slowly, working it through. "And the whole time, the thing that could actually affect their community has been sitting in your title documents." "They never checked," Marcus said. "They assumed the bridge was theirs. They maintained it for 37 years and never once looked at where the property line was." He said it without satisfaction. He'd practiced saying it without satisfaction, because satisfaction was not what this moment called for. This moment called for precision. This moment called for the same cold clarity he'd brought to infrastructure assessments in places where the wrong decision meant a bridge failed under load and people died. The HOA had built their entire campaign on an assumption. They'd harassed him, sued him, cost him $120,000 in legal fees, driven away his contractor, strained his marriage, and frightened his family, all from a position of institutional confidence that rested on a foundation they'd never bothered to inspect. The foundation was his. "I want to be clear about something," Marcus told Okafor. "I'm not interested in using this to punish anyone. I'm not interested in blocking the road or threatening access. Those are 340 families who need to get to work, and school, and the hospital. I'm not going to hold them hostage." "Then what do you want?" Marcus looked out the window again. The creek was barely visible through the tree line, just a glint of dark water in the November light. The bridge was out there somewhere, carrying the weight of an entire community's daily life, sitting on land that had been his since the day he signed the closing documents. "I want the lawsuit dropped," he said. "I want my permits approved without interference. I want the HOA to acknowledge, in writing, that they have no jurisdiction over my property. And I want a properly negotiated easement agreement for the bridge, one that reflects the actual legal reality of who owns what." "And if they refuse?" Marcus picked up the survey report from the table. He looked at the coordinates, the measurements, the surveyor's stamp. He thought about Colonel Reyes and the door the other side always leaves open. "Then we file a quiet title action on the bridge," he said, "and we let a judge explain to Victoria Ashford what the words trespass and adverse possession mean when the shoe is on the other foot." He didn't raise his voice. He didn't need to. The leverage wasn't in the volume. The leverage was in the paper, in the 4 inches of documented overreach and the certified survey report and the 1984 easement agreement that said exactly what it said and nothing more. But the HOA had spent 5 months trying to make Marcus Chen's life difficult enough that he'd surrender. They had spent 5 months doing it while standing on his land. The letter arrived on a Tuesday morning in October, and Marcus read it standing at his kitchen counter in the grey pre-dawn light, still in the clothes he'd slept in, a cup of coffee going cold beside his hand. It was 4 pages, typed on the letterhead of Hargrove, Pelletier, and Associates, the Atlanta firm the HOA had retained 6 weeks ago when their original lawyer, a local man named Denton, who had the good sense to look uncomfortable every time he filed something, quietly withdrew from the case. The new firm was different. They had the particular confidence of attorneys who had never lost a fight they controlled the terms of, and their letter read like a document written by people who expected it to be the last document necessary. The language was precise and total. The HOA, acting through its duly elected board of directors and pursuant to the community's governing documents and applicable county ordinances, was demanding that Marcus Chen execute a binding development restriction agreement within 30 days. The agreement would limit his 1,200 acres to agricultural and single-family residential use, prohibit commercial operations of any kind, require HOA pre-approval for any structure visible from Clearwater Ridge properties, and establish a permanent architectural review process over his land. In exchange, the HOA would withdraw its pending lawsuit and its objections to his building permits. The letter called this a settlement offer. Marcus set it down on the counter and looked out the window at the tree line, where the first pale suggestion of morning was beginning to separate the dark shapes of the oaks from the sky behind them. He had been awake since 3. He had been awake since 3 most mornings for the past 4 months. He picked up the letter again and read the final paragraph, which was the one that mattered. Failure to execute the agreement within 30 days will result in the HOA pursuing all available legal remedies, including but not limited to an emergency injunction prohibiting any development activity on the subject property, a declaratory judgment establishing community protective covenants over adjacent lands, and referral of the matter to county authorities for investigation of potential easement violations. The HOA is prepared to litigate this matter to its conclusion and has the full support of the Clearwater Ridge community in doing so. He folded the letter along its original creases and set it on the counter beside his coffee. Then he called Daniel Reyes. Daniel picked up on the second ring, which told Marcus his lawyer had already seen the letter, or had been expecting the call, or both. Daniel Reyes was 53 years old, a former JAG officer who had spent 12 years in military law before going into private practice in Asheville, and he had the quality Marcus valued most in a legal advisor. He never told you what you wanted to hear. He told you what was true, and he let you decide what to do with it. I got the same letter this morning, Daniel said. Courier delivered it to my office at 7. They sent it to you directly. Professional courtesy. They wanted me to see it before you did, I think. Wanted me to be the one to recommend you take it. Are you going to? There was a pause. Not hesitation. Daniel Reyes didn't hesitate. It was the pause of a man choosing his words with the care they deserved. No, he said. I'm not. Marcus exhaled. He hadn't realized he'd been holding his breath. Tell me where we are, Marcus said. All of it. Don't spare me, Daniel told him. The HOA's lawsuit was still active. The county's permit review had been stalled for 19 weeks, which was not technically illegal, but was the kind of administrative inertia that could stretch into years without the right pressure applied in the right places. The HOA had filed 2 additional complaints in the past month, one alleging that Marcus's survey stakes constituted a visual nuisance under the Community Standards Ordinance, and one claiming that his presence on the easement road during his own property inspections constituted trespassing. Both were frivolous. Both cost money to answer. Their legal fees were at $147,000. Marcus listened to all of it without interrupting. He had learned in the army that the worst thing you could do when receiving bad news was to flinch from it. You let it land. You felt the weight of it. Then you decided what it meant. The 30-day clock, Marcus said when Daniel finished. What happens if I let it run? They file for the emergency injunction. They'll probably get a temporary one. Judges don't like uncertainty around residential communities. They and the HOA has done a good job of making this look like a community safety issue, rather than what it actually is. We'd fight the preliminary injunction. We'd probably win eventually, but eventually could mean another 6 months and another $60,000. And if I sign their agreement, then it's over. You get your permits. You build your compound. You live on your land under their rules for the rest of your life. And every time you want to put up a fence, or plant an orchard, or add a barn, you go hat in hand to Victoria Ashford's board and ask permission. The morning had fully arrived now. The oaks were distinct and golden in the October light, and Marcus could see the roof of the old equipment shed at the edge of his property, the one he'd been meaning to repair since spring, and the one he hadn't touched because every dollar was going to Reyes and Associates. Daniel, Marcus said, I need you to file something. Tell me. I need you to file a formal notice of ownership claim on the bridge. The silence on the other end of the line was different from Daniel's usual pauses. This one had texture to it. Wait. Marcus, I've had the survey done. I had it done in August quietly by Hendricks. You know him. He's the best in the county. The bridge footings are on my property, not on the easement corridor. The easement grants right of passage over the road. It says nothing about the bridge, because when the easement was written in 1984, there was no bridge. The bridge was built in 1987. It was built on my land. The HOA has been maintaining a structure on my property for 37 years, without a maintenance agreement, without a license, without any legal instrument of any kind granting them the right to do so. Another pause. Longer. You've known this since, when? Week 2. Daniel made a sound that was not quite a laugh. You've been sitting on this for 5 months. I've been documenting for 5 months. I have the original 1984 easement language. I have the 1987 county building records showing the bridge construction date and location. I have Hendrix's survey with GPS coordinates, placing the bridge footings 34 feet inside my property line. I have 40 years of HOA maintenance records. They published them in their annual reports, Daniel. They were proud of maintaining the bridge. They put it in their newsletters, and not one of those records references any legal right to be on my land to do it. He could hear Daniel breathing. If I file a notice of ownership claim, Daniel said slowly, working through it as he spoke. The HOA has to respond. They have to produce documentation of their right to maintain that structure, and they can't because there isn't any. No, there isn't. And if they can't establish a legal right to maintain the bridge, then they have no legal right to be on my land for any purpose related to that bridge, which means every repair, every inspection, every maintenance visit for 37 years was unauthorized access to private property. Marcus. Daniel's voice had changed. The careful neutrality of a lawyer managing a difficult client had given way to something else. Something that sounded almost like admiration, though Daniel Reyes was not a man who admired things easily. They have 340 homes on the other side of that bridge. I know. That bridge is the only road connection to the county highway. I know. If you establish ownership of the bridge and revoke their maintenance access, I'm not going to revoke their access, Marcus said. Not yet. I'm going to establish that the access is mine to grant or revoke. That's different. That's the point. He walked to the window. The morning light was full now, honest and clear, the kind of October light that made everything look like it had edges again after the blurred exhaustion of summer. They sent me a letter this morning telling me to sign away my rights to my own land, Marcus said. They have been harassing me for 5 months. They have cost me $147,000. They have stalled my permits, pressured my contractor, leaked stories to the newspaper, and filed complaints so frivolous that their own first lawyer quit rather than keep signing them. They have done all of this because they assumed I would eventually get tired and comply. They assumed that because they have institutional power and I am one person, the math would eventually work in their favor. He paused. They never checked the property records. In 5 months of aggressive litigation, they never once looked at the historical survey data for the bridge. They assumed it was theirs because they'd been maintaining it. They assumed that because they had been acting like they owned it, they did own it. That's not how ownership works, I know that. They're about to learn it. Daniel was quiet for a long moment. When he spoke, his voice was measured and precise, the voice of a man who had spent his career in rooms where precision was the only currency that mattered. If I file this, he said, there's no going back. They will understand immediately what it means. Victoria Ashford will understand what it means. This stops being a harassment campaign and becomes something else entirely. I know what it becomes. It becomes a negotiation where they need something from you. Yes, and you're ready for that. Marcus looked at the letter on his counter. 4 pages. 30 days. Sign away your rights, or we will make your life more difficult than it already is. The specific logic of people who had never been told no by someone who could afford to mean it. He thought about the easement document he had read in week 2 of ownership, sitting at this same counter, the original 1984 language typed on paper that had gone soft with age. He thought about the moment he had understood what it meant, not with triumph, but with the quiet recognition of a man who has found the load-bearing wall in a structure everyone else assumed was solid. He had set the document down carefully. He had taken a photograph of every page. He had called Hendricks the next morning and asked for a discreet survey. He had waited. He had documented. He had let them spend 5 months building a case on a foundation they had never bothered to inspect. File it today, Marcus said. File it before they leave their offices for lunch. I want Victoria Ashford to have it in her hands by 2 o'clock. Understood. And Daniel, make sure the filing is complete. Every exhibit, the 1984 easement, the 1987 building records, Hendricks' survey, all of it. I don't want them to have any ambiguity about what we're claiming or any doubt that we can prove it. I'll have it filed by noon. Marcus picked up his cold coffee and drank it anyway. Outside, the October light lay across his land, all 1,200 acres of it, clear and legal and entirely unambiguously his. And somewhere 2 miles east, beyond the tree line, beyond Clearwater Creek, the bridge sat on its footings in the ground that had always been his ground. waiting, as it had waited for 37 years, for someone to finally ask who it belonged to. Now, someone had asked. The answer was going to change everything. But the morning Victoria Ashford received the certified letter from Marcus Chen's legal team, she was standing in her kitchen in a silk robe, holding a coffee cup that cost more than most people's car payments, and she was not afraid. She had faced down zoning boards, county commissioners, rival developers, and 2 separate recall campaigns during her tenure on the Clearwater Ridge HOA board. She had survived all of them. She had survived them because she understood one fundamental truth about institutional power. The person willing to make the most noise, file the most paperwork, and sustain the most pressure almost always wins. The law, in her experience, was a secondary concern. Endurance was the primary weapon. She set down her coffee and opened the envelope. She read the first paragraph twice. Then she called her attorney. The call lasted 11 minutes. By the end of it, the coffee was cold, and Victoria Ashford was sitting down. What Marcus's legal team had filed was not a countersuit in the traditional sense. It was something more precise, more surgical, and, in its own way, more devastating than any damage claim could have been. It was a formal petition for declaratory judgment on property ownership. Specifically, ownership of the 847-square-foot concrete and steel structure spanning the eastern fork of Clearwater Creek at the terminus of Ridgeline Drive. The bridge. The petition was 43 pages long. It included the original 1984 easement grant, the 1987 county construction permit issued to the original landowner, the survey coordinates placing the bridge's foundation entirely within the boundaries of what was now Marcus Chen's 1,200 acres, and 37 years of county tax records showing that the bridge had never, not once, been assessed as HOA property, because it had never been HOA property. It had simply been used as HOA property, which is a different thing entirely, and the difference was the kind that ends careers. Marcus's attorney, a quiet woman named Diane Okafor, who had spent 20 years doing nothing but property rights litigation in 3 states, had attached a supplemental brief that laid out the legal consequence in language so plain it almost seemed cruel. The HOA had no ownership interest in the bridge. The HOA had no recorded easement covering the bridge's footprint. The HOA had been performing maintenance on a private structure without authorization, without a maintenance agreement, and without the knowledge or consent of the lawful owner. Under state law, this constituted unlicensed use of private property. The HOA's right to cross the bridge, the right upon which 340 homes depended for their only road access to the county highway, rested entirely on the goodwill of Marcus Chen. Goodwill the HOA had spent 8 months systematically destroying. Victoria's attorney, a man named Gerald Fitch, who billed at $400 an hour and had never once in 15 years of HOA representation encountered a situation like this, told her 3 things in rapid succession. First, the petition was legitimate and would almost certainly succeed. Second, the HOA's prior legal campaign against Marcus, the ordinance, the injunction filing, the county permit pressure, had created a documented record of bad faith that would make any negotiation significantly more expensive. Third, and most importantly, if Marcus Chen chose to exercise his property rights to their fullest legal extent, the HOA could not stop him. He could close the road. He could restrict access to the bridge. He could, pending proper legal notice and a reasonable transition period, effectively strand Clearwater Ridge. Gerald Fitch did not use the word hostage. He was too professional for that, but the concept occupied the room like a physical presence. Victoria told him to find a way out. He told her there wasn't one that didn't involve Marcus Chen. The HOA board met in emergency session 2 days later. But Marcus knew about the meeting because one of the board members, a retired school teacher named Howard Briggs, who had voted against the original ordinance and had been quietly appalled by everything that followed, called Marcus's attorney and told her what time it started. Howard Briggs had 3 grandchildren he wanted to be able to drive to his house without a 40-minute detour, and he had decided that loyalty to an institution that had lost its mind was not a virtue he was willing to maintain. The meeting lasted 4 hours. Marcus was not there, but Diane Okafor had prepared him a likely scenario, and it played out almost exactly as she predicted. Victoria argued for continued resistance. She suggested the HOA could challenge the survey, challenge the historical records, challenge the chain of title. Gerald Fitch explained, though with the patience of a man who charged by the hour and therefore had no incentive to be brief, that the chain of title was unassailable. Marcus Chen's ownership was not a matter of interpretation. It was a matter of recorded fact. The county had the documents. The state had the documents. The original landowner's estate had the documents. There was no version of this story in which the bridge belonged to the HOA, because the bridge had never belonged to the HOA, and the only reason anyone had believed otherwise for 37 years was that no one had bothered to look. That was the sentence that broke something in the room. No one had bothered to look. The HOA had built an entire campaign of institutional aggression. Ordinances, lawsuits, media pressure, permit interference, against a man whose property rights were so thoroughly documented that a first-year law student could have identified the problem in an afternoon. They had assumed. They had assumed the bridge was theirs because they had always used it. They had assumed their jurisdiction extended to Marcus's land because no one had ever told them otherwise. They had assumed their institutional weight was sufficient to make a retired army officer bend, because institutional weight had always been sufficient before. Every one of those assumptions was now a liability. Victoria Ashford left the meeting before it formally adjourned. Howard Briggs watched her go. He had known her for 6 years, had sat across from her at dozens of board meetings, and he had never seen her look like that. Not diminished exactly, but recalibrated, as if some internal instrument she had always relied on had just returned a reading she didn't know how to process. The board voted 4-1 to authorize Gerald Fitch to open settlement negotiations with Marcus Chen's legal team. The one dissenting vote was Victoria's, cast remotely by phone from her car in the parking lot. It didn't matter. The motion passed. Marcus was sitting on his back porch when Diane called him with the news. The sun was going down over the western ridge of his property, painting the creek gold, and the bridge was visible from where he sat. A modest concrete span, nothing dramatic, the kind of infrastructure that exists in 10,000 rural counties across the country, and that no one thinks about until it isn't there. He had looked at that bridge every evening for 8 months. He had looked at it the way a chess player looks at a piece that hasn't moved yet. Diane told him the HOA had blinked. She told him they wanted to talk. He asked her what she thought they'd offer. She said they'd probably start with money. They'd offer to buy the bridge outright, or to purchase a permanent easement, or to establish some kind of maintenance agreement that gave them the legal standing they'd never had. They would try to make this a transaction, because transactions were something they understood. Transactions were something that could be controlled. Marcus said he understood. He sat with the phone in his hand after she hung up and watched the last light leave the creek. He thought about the permit still sitting in the county office, unprocessed. He thought about his contractor, who had walked away. He thought about the $140,000 in legal fees, and Patricia's face across the dinner table in month 4 when she had asked him, quietly, whether this was worth it. He thought about what the HOA had done, and why they had done it, and how certain they had been. Then he went inside to find Patricia and tell her that the conversation they were about to have with Clearwater Ridge was going to be conducted entirely on his terms. For the first time in 8 months, he was not the one being summoned. The document Marcus signed on a Tuesday morning in October was 11 pages long. His lawyer had reviewed it 4 times. The county recorder's office had reviewed it twice. A title company out of the state capital had reviewed it once, at Marcus's request and Marcus's expense, because he wanted no ambiguity. He wanted the language so clean it could survive a century of challenges without a comma out of place. He signed it at the kitchen table of the farmhouse he'd finally finished building, 6 months behind schedule, with a contractor he'd hired from 3 counties over after the first one walked away. Patricia sat across from him with coffee she wasn't drinking. Outside, the November light was flat and grey over the valley, and the creek ran low and quiet under the bridge that had started all of it. The document was a recorded easement agreement, the new one, the real one, the one that would govern the relationship between Marcus Chen's 1,200 acres and the 340 homes of Clearwater Ridge for as long as either existed. It was not the document Victoria Ashford had wanted. The terms were straightforward, and in the way that a surgical incision is straightforward, precise, deliberate, and impossible to misread. The road through Marcus's property would remain open. The bridge would remain passable. Clearwater Ridge's residents would continue to have access to the county highway because Marcus had never wanted to strand them. That had never been the point. The point was something else entirely. And the 11 pages made the point with the kind of clarity that only comes from a man who spent 26 years in the Army Corps of Engineers, learning that the difference between a structure that holds and a structure that fails is almost always a matter of documentation. The HOA would pay an annual easement fee. The figure was not punitive. Marcus had resisted his lawyer's early suggestions of something designed to sting, when something calibrated to remind the board every year what their arrogance had cost them. He didn't want a reminder. He wanted a record. The fee was set at fair market value for a commercial easement of equivalent scope, established by an independent appraiser, indexed to inflation, and payable on the 1st of January. It was the kind of number that a reasonable organization would have agreed to in month 1, before the lawyers, before the newspaper stories, before the $140,000 in legal fees that Marcus had spent fighting a war he hadn't started. The HOA's new Community Standards Ordinance, the one Victoria had pushed through in month 1 with such institutional confidence, had been vacated by the county 3 weeks earlier. The judge had used the word void in her ruling, and she had used it without hesitation. And she had noted in her written opinion that the ordinance had been applied to a property over which the HOA possessed, and I am quoting the judge directly here, no colorable legal authority whatsoever. The HOA's lawsuit, the one claiming nuisance by anticipation, the one built on the premise that Marcus might someday do something they didn't like, had been dismissed with prejudice in September. Victoria Ashford had resigned from the board in October, citing personal reasons, which was the kind of phrase that means everything and explains nothing. The new board had called Marcus's lawyer in the first week of November. They were younger, most of them. A retired schoolteacher named Donna Reyes was serving as interim president. She had not been on the board during any of it. She had, in fact, voted against the original ordinance and been overruled. When she called, she did not offer an apology on behalf of the institution, because institutions rarely apologize, but she said something that Marcus thought was more honest than an apology would have been. She said, "We need to fix this properly. Tell us what properly looks like," Marcus had told her, and now he was signing 11 pages that described it. The bridge maintenance clause was the one his lawyer had spent the most time on, and it was the one Marcus had thought about the longest, lying awake in the farmhouse in the weeks after the lawsuit collapsed, listening to the creak and thinking about what it meant to own something that other people needed. The clause established a joint maintenance protocol. The HOA would contribute 60% of annual maintenance costs, reflecting the proportion of use. Marcus would contribute 40% and retain all ownership rights and final authority over any structural decisions. An independent civil engineer, agreed upon by both parties, would conduct an annual inspection. The report would be shared with both parties and filed with the county. It was, in other words, exactly the kind of arrangement that should have existed for 37 years. The kind of arrangement that a competent HOA board in 1987, when the bridge was built on land they didn't own, should have established with the landowner they were building on top of. They hadn't done it because they hadn't checked. They hadn't checked because it hadn't occurred to them that the land might belong to someone who would ever matter. Marcus thought about that sometimes, not with bitterness exactly, but with something more like the particular tiredness that comes from watching a preventable thing happen anyway. He had spent his career building infrastructure in places where the consequences of not checking were measured in lives. A bridge that fails in a combat zone. A water system that collapses in a flood. He had learned, at considerable cost to his sleep and his peace of mind, that the people most likely to skip the verification step were the people most certain they already knew the answer. Victoria Ashford had been certain. That was the thing that had made her so dangerous and, in the end, so vulnerable. She had been certain that Marcus was a threat to be neutralized, certain that her institution had the power to neutralize him, certain that the law was a tool that moved in the direction of whoever applied it most aggressively. She had never once considered that the man she was threatening had read every document in the county recorder's office, had photographed every survey marker on his property, had known about the bridge's legal status since the second week of ownership, and had been waiting, with the patience of someone trained to wait, for the moment when her certainty became the mechanism of her own undoing. He signed the last page. His lawyer witnessed it. Patricia finally drank her coffee. Later that afternoon, Marcus walked out to the bridge alone. The creek was low enough that he could see the concrete footings on his side of the bank, the ones that had been poured in 1987 on land that had never belonged to anyone but the original farmer, and then, after a clean title transfer and a meticulous survey, to him. He stood on the bridge for a while. Why cars would cross it today, the way they crossed it every day, carrying Clearwater Ridge residents to the highway and back. They would cross it tomorrow. They would cross it in 10 years. The bridge would hold because bridges built correctly tend to hold, and because now there was a maintenance protocol and an annual inspection and a civil engineer whose job it was to make sure. The valley was quiet. His 1,200 acres ran out in every direction, past the tree line, past the ridge, past the places he hadn't yet walked. He had plans for some of it, a second structure for his daughter's family, a small orchard on the southern slope. Nothing dramatic, nothing that required anyone's approval. He owned it, completely, legally, unambiguously. He had the survey and the title and the 11 pages he'd signed that morning, and he had the judge's ruling with the word void in it. And he had the knowledge that the institution that had tried to take something from him had failed not because it lacked power, but because power applied without verification eventually encounters the thing it failed to verify. He turned and walked back toward the farmhouse. The light was already going. Patricia had started dinner. The compound, his compound, the one his family had almost given up on, was lit from the inside, warm against the grey afternoon. He went in.